Ever since the FBI executed its search warrant at Mar-a-Lago, many of the former president's defenders and even some of his detractors have been quick to compare the entire ordeal to the investigation of Hillary Clinton's handling of government communications while Secretary of State, her emails. Many in the media and prominent lawmakers on Capitol Hill are now once again relitigating the Hillary saga, trying to make comparisons. Some even suggesting that what Hillary Clinton did is worse.
Is it right for the president to take these government documents, which he's supposed to turn over to the National Archives, down to Mar-a-Lago?
You should be very careful with classified documents. I've had access to documents like that for a long time. I'm incredibly careful. I was wondering as I was listening to that discussion if the same things were said when Secretary Clinton had documents, when Director Comey had documents. They had them on the internet, which is much more dangerous than having them in a box somewhere.
Before I explain why I don't believe this comparison quite works, let me be transparent with you on where I stand on each of them. In 2016, I said Hillary Clinton was reckless, and her decision to use a private server was absolutely wrong, even though she said she did nothing wrong. That year, I wrote on abcnews.com, it's critical to start by separating foolish and even potentially shady behavior from criminal. It should be clear to any objective observer that it was an enormous error for Clinton to use a homemade server for all of her emails while she was in a position that regularly handles and assesses the most sensitive of government secrets. I also did not believe that she should be prosecuted because you didn't have the level of intentionality needed to keep or hide government documents. That's what the FBI found, and that made sense legally to me. Meanwhile, as I said last night, I'm not yet convinced that former President Trump should be indicted either. That will depend on what we learn about his level of intentionality. That doesn't mean he shouldn't be. I'm just saying that unlike the left-leaning media who've already decided that the former president is going to be in cuffs, we need to wait and see. With Hillary's situation, you had the intention to create a private server, and it seems it was to avoid freedom of information requests. It was wrong. Same way, if President Trump had just been circumventing the Presidential Records Act, I'd say wrong, but certainly shouldn't be charged. The key is you didn't have her intentionally removing top-secret documents. The claim that she destroyed thousands of emails, while true, the FBI found zero evidence that they were deleted deliberately to avoid a subpoena. Clinton's team had requested that what they said were her personal emails be deleted months before the subpoena came. And none of the emails were clearly marked as classified, even though some of the information in them turned out to be. And, in addition, not all of those, quote, personal emails ended up being personal. A Clinton aide also destroyed 2 of Clinton's phones, but at the time, disposing of the phones was not considered unusual. Pretty common to get rid of devices so that data stored on them wouldn't fall into the wrong hands. Now, President Trump has been accused of flushing sensitive documents in the White House toilet. I don't think he should be charged for that either. Meanwhile, in the Trump case, if the highly classified documents were subpoenaed and he intentionally didn't turn them over, that's different. And that doesn't even address the fact that whatever classified documents passed through Clinton's email server, they don't appear to have been at the very highest level, the most preciously guarded secrets, as it appears Trump's were. But again, we need to wait and see. Republicans at the time continued to call her a crook. On the campaign trail, Trump made a promise that there would be no more funny business when it came to classified documents.
In my administration, I'm going to enforce all laws concerning the protection of classified information. No one will be above the law.
Well, now the spotlight is on him. On August 8th, when FBI agents seized classified documents, one set at the very highest level, top secret SCI, rather than wait to see what the FBI has, some Trump allies like Lindsey Graham are trying to gin up the outrage machine.
If there's a prosecution of Donald Trump for mishandling classified information after the Clinton debacle, which you presided over and did a hell of a good job, there'll be riots in the streets.
Putting aside the danger in talking about riots, Lindsey Graham is being very lawyerly by referring to mishandling classified information, because that's not one of the statutes Trump is even being investigated for. That's what Donald Trump's legal team wishes he was being investigated for, because then it would all probably come down to classification. But he's not. It's a separate statute. Graham knows that. When he appears on Fox, he knows he needs to create outrage. So I'll say it again, these are two polarizing figures, but with very different sets of facts. And in one case, we don't even have all the facts. But hey, in the world of cable news, why would that stop both sides' political media machines from fomenting outrage? But based on what we know today, sure seems like what Donald Trump has done is worse. Doesn't mean it will necessarily be criminal, but it also doesn't mean the comparison works. Joining me now, someone who may not agree with me, Mark Weaver, the former Deputy Attorney General of Ohio, who also served in Ronald Reagan's Justice Department. Mark, thanks a lot for coming on the program. Appreciate it. All right, what do you think I'm getting wrong here?
Well, you got some things right. I agree when you say we don't know all the facts yet about Donald Trump. The Justice Department, where I worked, has been illegally leaking grand jury information. That's a crime. That's how we know things. Someone's breaking the law by telling us. So you're right, we don't know a lot about what happened in the Trump case. What we know about the Clinton case came directly from FBI Director Comey in public statements. So we're talking about clear evidence versus shadows of evidence put forward by the Biden Justice Department
that's true.
Against criminal law.
Yeah, no, there's no doubt we know I think we can all agree on the facts in the Hillary Clinton case. We have the records, we have the documents, we have Comey's statements, et cetera. But I still don't think, based on even what we know about the Trump investigation, that it's a very good comparison for supporters of the former president to be making to say, well, what about Hillary Clinton? Even based on what we know today, it seems like Donald Trump's actions, based on where the investigation is worse than Hillary Clinton.
No, it's the other way around. Here's why. Article 2 gives the President of the United States complete plenary authority to decide what's classified and what's not. The Secretary of State, which is what Hillary Clinton was, has no authority to do that. When she kept those classified emails on an unsecured server, which we still don't know who got into that server, that was a clear violation. In your opening, you said the word reckless. You're exactly right. She was reckless. James Comey refused to use that word. He said extremely careless, right. But the mens rea for the statute she violated, you were right, Dan, it was reckless, and that meets the mens rea for that statute.
So let me answer that two ways. First of all, on the issue of the classification of the documents, as you know, for the various statutes, it doesn't even need to be, quote unquote, classified. It just makes it worse, right? It makes it worse the higher classification the documents are. You don't need it to be classified for some of these statutes. And number two, yes, it's true. Recklessness, but if you're going to say that recklessness is the standard and that's all, no intentionality, then Donald Trump is probably going to get charged. I don't apply that standard when it comes to that statute. I require, and the Supreme Court has suggested, that there has to be intentional conduct, not just negligence, not just recklessness. That's why Hillary Clinton didn't get charged, and that is why Donald Trump might not get charged.
Well, I think we're talking about different statutes here. The one James Comey spoke about when he announced the Clinton decision in October of 2016, specifically the mens rea for that federal statute was reckless, and he refused to say the R word. He said instead extremely careless, which is actually a translation of the word reckless from legal to English.
Yeah, but that's the same statute that Trump's being investigated for. It's the espionage statute. It's 793. Sure. It's the same one. So the bottom line is, so you're ready to say Donald Trump should be prosecuted if he was reckless?
No, what I'm saying is Congress cannot limit the president's authority to declassify. But
that's a separate issue. You know that statute doesn't. Wait. Come on. You're playing games now, Mark. You know that statute does not refer to classified documents. It refers to information in the national defense. And that's why everyone, when they wanted Hillary Clinton to get prosecuted, kept saying, it doesn't even need to be classified. They can prosecute her under this. My point is just that it's a dangerous world where we start applying these different standards to different people. I'm applying the same standard. I applied that standard to Hillary Clinton with regard to intentionality back then. I'm applying the same standard to Donald Trump today. I'm afraid maybe you're not, but I'll give you the final word on that before I bring in Mark Zaid.
Sometimes we do treat people differently because the president has Article II authority that the Secretary of State does not. And Congress, according to the U.S. Supreme Court in '88, Navy versus Egan, Congress cannot impinge on the president's ability to make decisions about documents like that.
Right. But again, I'm not talking about whether it's classified or not. But let me bring in National Security Attorney Mark Zaid, who represented both the RNC and has represented, liberal media companies and conservative media companies. He's represented just about everybody, and specifically represented some of the media companies in an effort to obtain Hillary Clinton's emails. Mark, thanks very much for coming on the show. Appreciate it. You've heard the other Mark and I going back and forth on this one. Where do you land on this in terms of, does the comparison work? Is it fair to say Clinton versus Trump, et cetera?
I'm like-minded with you, Dan. I feel the same way. I was very critical, still am, of what Hillary Clinton and her senior staff did. In fact, I'm still angry about how irresponsible they were in not realizing what they were doing was the wrong way to proceed. But we're talking about very different provisions in the statute. And a lot of people don't understand, in fact, experts oftentimes don't understand about this because the statute, the Espionage Act, is rarely used. I deal with it regularly. There are very few prosecutions under the statute, and there are very different provisions under the statute. In fact, there are 3 different provisions that we're really talking about between Hillary Clinton and Donald Trump's situation, and they are completely different from one another. And of course, they don't have anything to do with espionage per se, in the sense of what historically this act was created for, which was to prosecute people like Alger Ames and Robert Hansen. We're dealing with this national defense information, which is equatable nowadays to classified information. I don't think anyone would ever be prosecuted for just unclassified national defense information unless it was of such volume to be, beyond the pale of what we have ever seen. I mean, look, I had a client prosecuted during the Clinton email scandal. In fact, we cited the Clinton defense as a way for us to avoid jail time, which we did, because they were in possession of classified or national defense information relating to East Germany, which for most of your viewers, I hope they realize there is no East Germany any longer.
Right. So, Mark, where do you think that this? Before I go back to Mark Weaver, let me ask Mark Zaid. Mark Zaid, where do you think this Trump investigation goes from here?
Yeah, I do think that as we learn more facts, it is more likely that someone is gearing towards indictment. But I agree with you. There's a lot more we need to know. The FBI may know a lot of this information already. Who's on the surveillance video of Mar-a-Lago going in and out of the rooms, bringing in boxes from one to the other? I also agree, and I'll emphasize maybe a little bit more detail, the difference between one, Hillary Clinton cooperating throughout the entirety of the investigation and her staff versus what perceived to be, and I think all the difference in the world, that if this had stopped in May and Trump and whoever had returned everything, I think nothing ever would have happened. No prosecution. Everybody would have just washed their hands and gone home. Whatever or whomever came forward, and we'll find out maybe at some point in time, to say that what the lawyers were saying was not true, that there still was classified information or national defense, whatever, present at Mar-a-Lago, which obviously the FBI search revealed. Yeah. Boxes and boxes of it. That's going to be, in my mind, the difference as far as someone being prosecuted or charged. But I don't know if that's Trump yet.
I've got 30 seconds. Let me give Mark Weaver a final thought on this.
We had a good legal colloquy, Dan, back and forth, but I'm going to agree with you on one thing. This country cannot withstand different treatment for 2 different political presidential candidates, Hillary Clinton in 2016 and Donald Trump twice. And so if Donald Trump were to be prosecuted when Hillary Clinton was not, politically speaking, it would tear this country apart. It would be extremely imprudent for Merrick Garland to do that, particularly as somebody who has a dislike of Donald Trump. He needs to step aside and have a special prosecutor if he's going to move forward.
And then all I would say is if there is a charge, I hope folks like Mark Weaver, who are well respected within the Republican Party, look at the indictment and the facts carefully and just help explain to people. If there is. Again, I'm still saying that I think there's probably not going to be. So we shall see. Anyway, Mark Weaver, good conversation. Mark Zaid, thanks so much for coming on the show. Really appreciate it.
Thank you.
Coming up, you need a photo ID to apply. Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.